Assalamualaikum warahmatullahi wabarakatuh, and hi to Puan Wan Yasima and my fellow friends. Before we begin our presentation, let me introduce myself and my group members. My name is Nur Hidayati binti Zainorin. My metric card number is 01DPM 19F1029, and I am the group leader. My other group members are Nur Fizana binti Abdul Muttalib, 01DPM 19F1024, Seri Putri Balkis binti Hasib, 01DPM 19F1015, and Fatiha Nur Aisyah binti Muhammad Nizam, 01DPM 19F1028. In this video, we are going to present about direct negotiation between Apple and Samsung. So, without wasting any time, let's get started with an introduction. Apple and Samsung have been at the center of an extraordinary court battle for the past 4 years. It began in 2010 with the release of Samsung Galaxy S smartphone, which much to Steve Jobs' surprise, resemble and employ similar technology to the iPhone, his company's breakthrough phone release 3 years prior. Patent, technological, and invention disputes cost both organizations tens of millions of dollars, cover 4 continents, and have still to be resolved 5 years later. Now, I will explain to you the background of these two companies. Samsung and Apple are both giants in the personal computing industry. Apple is an American prominent hardware and software company founded in 1976 by Steve Jobs, Stephen Wozniak, and Ronald Wayne. It is a consumer electronics company that designs, produces, and sells products. Apple has a high level of brand loyalty and is one of the most valuable brands in the world. Apple has been one of the most innovative influences on industry practices throughout the history of personal computing and has continued to be a driving force in the advancement of the personal computer, with other businesses attempting to narrow the gap. Now, background of Samsung. Samsung, founded in 1938 by Lee Byung-chul, is the largest multinational enterprise company in South Korea. Over the next 3 decades, the company diversified into areas including food processing, textiles, insurance, securities, and retail. Samsung entered the electronics industry in the late 1960s. And for your information, Samsung Electronics has been ranked as the world's largest information technology company measured by 2014 revenues, with a revenue of 189.5 billion, whereas Apple has been ranked second with a revenue of 182.79 billion. The relationship between these two companies has been quite complicated. Samsung is an important supplier of parts for Apple products. Samsung provides some of the iPhone's most important components, including the flash memory, which stores the phone's apps, music, and operating software, as well as the working memory and application processor, which keeps everything running. Apple was one of Samsung's top customers, and Samsung was one of Apple's largest suppliers, and the two businesses had a successful business partnership. But on August 4, 2010, their working partnership turned even worse when a small group of executives from Apple Incorporation arrived in Seoul to the Samsung headquarters, ready to fire the first shot in what would become one of the bloodiest corporate wars in history. The conflict had been brewing since spring, when Samsung launched the Galaxy S, a new entry into the smartphone market. It was only 3 years after Apple has launched its first generation of iPhones. In the article The Great Smartphone War by Kurt Eichenwald reveals Steve Jobs and his CEO, Tim Cook, had talked with Samsung chairman Lee Jae-yong in July to voice their dissatisfaction with the phone's similarities, but had received no satisfactory response. So, in these cases, they will resolve the conflict through direct negotiation. What is direct negotiation? Direct negotiation are generally acknowledged as one of the most effective and efficient peaceful methods for resolving international disputes, convening treaties, and achieving the interests of negotiation parties without the involvement of third parties. In the case of Samsung and Apple, they chose this strategy since it involved no third parties and can be settled effectively. But what exactly is the issue going on between Apple and Samsung? Nurfrizana will continue the presentation.
Assalamualaikum and hi, my name is Nurfrizana binti Abdul Muttalib, 01DPM 19F1024. And today, I will talk about the issue that happened between Apple and Samsung. First thing first, both companies believe they have a crucial invention, patent, and are trying to protect their rights. Steve Jobs said in 2007 that over the previous several years, we've come up with some wild ideas. For all of the invention in the iPhone, we filed over 200 patents and we intend to protect them. Samsung has a patent arsenal that rivals Apple's, including several that cover essential cellular phone technology that Apple relies on, but is difficult to enforce in court. Before the trial, Apple claimed that Samsung demand 2.4% of every iPhone and iPad sold to protect its patent violation. While Apple must pay royalties on certain of phones' patent, it believes the 2.4% rate is excessive, considering that the technology Samsung claims to possess is found in Intel processor that Apple purchased for $6 to $10 each. In 2011, Apple filed a lawsuit against Samsung Electronics Company, alleging that they were infringing on Apple's intellectual property, made the conscious choice to copy Apple's iPhone and iPad. Apple's intellectual property claim against Samsung was crucial to the iPhone and iPad phenomenal success. Apple then alleged that Samsung had infringed on 4 industrial design patents that covered the device's appearance and feel, as well as 3 utility patents that covered how it worked. In June 2011, Samsung, the world's largest smartphone manufacturer, filed a countersuit against Apple, alleging that Apple had infringed on key of its patent pertaining to wireless communication technology and camera phones. Apple, which introduced its first iPhone roughly 20 years after Samsung being developing mobile phone technology, is unlikely to sell an iPhone without the benefit of Samsung's unique technology, Samsung noted in a description of the trial. Apple relies on Samsung for around 26% of the component in each iPhone. The CEOs are occasionally directly involved in the negotiation, although they are more commonly represented by their counsel. In May 2012, Apple CEO Tim Cook and Samsung CEO Gi Sang-choi meet with a court in California to try to reach an agreement in a high-profile patent issue. On both sides, several lawyers were involved, with Apple being represented by Maurice Forster and Wilmer Hale in San Francisco, and Samsung being represented by Quinn Emanuel in New York. Maurice Forster's Harold McElhinney is a lead lawyer who previously sued Samsung and won $59 million in damage for pioneer in a patent dispute over plasma TV panel. William Lee, a partner of Wilmer Hale, has conducted a number of patent-related inquiries. The measure of the flow time for Samsung went to John Quinn and Quinn Emanuel partner Charles Verhoeven. So, that's all from me. Now, I will call upon Sri Putri Balkis to continue the presentation.
Assalamualaikum, my name is Sri Putri Balkis binti Asif and I will explain about the outcomes of the agreements received from the cases we discussed between Apple Incorporations and Samsung. First things first, what is a settlement agreement? A settlement agreement is a legal contract in which all parties comes to an agreement to resolve their differences. It is a legal instrument in which the parties in a civil law dispute agree in advance to the outcome of any verdict. In most cases, settlement agreements eliminate the needs for a lengthy court dispute, saving clients both time and money. Rather of a trial, settlement agreements are reached through mediation. However, after a settlement is reached, the judge will decide whether to or not to approve it. Settlement agreements allow both parties to be tough while still being happy with the results. So, how are the settlement agreements enforced? The courts have the authority to enforce settlement agreements between the parties in the case. A settlement agreement once signed by the relevant parties is legally binding contract if all the terms are deemed valid. But it is important to note that courts do not have inherent power to enforce settlement agreements after a case has been dismissed. So, what is the purpose of a settlement agreement? Drafting a settlement agreement may be one of your legal choices if you want to settle your disagreement without having to go to court. In exchange for the other party's pledge to discontinue legal proceedings, one party must accomplish an action or pay a specific sum. So, in this case, Apple and Samsung have reached an agreement to settle their long-running patent dispute over smartphone design patents, putting an end to 7 years of judicial warfare between the two tech titans. Negotiations are required before any settlement agreements can be reached in order to agree on specific provisions. If necessary, a mediator can help you to come to an agreement on a factual account of the problem. In some business settlements, one side may agree to settle solely if there is no need to admit wrongdoings or culpability. Returning to our primary case, a settlement was reached in May by a jury in the United States District Court for the Northern District of California after discovering that Samsung had infringed on Apple's patented design for things like the home screen layout. As a result, there were more appeals and countersuits. Samsung must pay Apple $539 million in damages, according to the judge. Rather than filing an appeal, the firms have agreed to settle their disagreements outside of the courtroom. The terms of that settlement, however, have not been made public. After reaching the Supreme Court, Samsung's payment was lowered and the case was remanded to a lower court. They have agreed to drop and settle their remaining claims and counterclaims in this suit. The order was ordered by Judge Lucy Koh of the Northern District of California, dismissing all lawsuits with prejudice, which means no further lawsuits can be brought on the same claim. The settlement's terms still remain unknown to these days. Since Apple and Samsung launched their legal war, the smartphone market has changed dramatically. While the top two smartphone makers in the world are still in intense rivals, the dynamics between them have changed. Apple, the world's most valuable company, continues to focus on high-end smartphones, while on the other hand, Samsung has moved on its focus to luxury, original design, and is credited with pioneering the smartphone industry's trend towards larger phones. Apple and Samsung's long-running patent war is now over thanks to a settlement agreement signed between these two. So that's all from me, and I will pass it on to the next presenter.
Hi, my name is Fatihah Nur Aisyah binti Muhammad Nizam, and now I will explain about my part, which is procedure in solving between Apple and Samsung. Let me start it with in August 2010, Apple believes that their partner Samsung has infringed on Apple patents and would like to work out a deal. So Apple and Samsung meet to discuss. Samsung resolving the issue by licensing right, whereas Samsung had to pay per each tablets and phone to Apple, but Samsung declines it. Apple files a lawsuit against Samsung. Even Samsung files international countersuit over 3G technology patents. It says that Apple has infringed on. In August to September 2011, courts ordered Samsung tablet to be pulled from the shelf as they are deemed to closely resemble the iPad. So 30 more lawsuits are filed focusing on specific aspects of the devices and their function from both sides in the UK. Apple is ordered to admit that Samsung did not copy the iPad design. In August 2012, jury awards Apple over $1 billion, saying that 26 products infringed on Apple patents. Blow to Apple when US Patent of Trademark Office tentatively denies patent of pinch to zoom feature, calling into question other patented features. In June 2013, the International Trade Commission rules order iPhone and iPads infringe on Samsung patents and should be banned in the US. Retrial held over the miscalculated damage of prior trial, so the damage award to Apple are now 129 million, down from 1.05 billion. In May 2020, 14th jury rules that Samsung infringed on 2 Apple patents and awarded Apple 190 million in damage. So the jury also found that Apple had infringed on one of Samsung patents, awarding Samsung 158,400 in damage. And for the last one, August 2014, Apple and Samsung agree to settle all the patent disputes of the US between themselves. I guess that's all from my part. I will pass to the next presenter.
Unconsciously, this video has come to an end. So the conclusion is, the Apple versus Samsung case not only reminds us of the importance of filing multiple design patents for protecting a new product's look, but also the significance of conducting a patent search. In the ongoing war between Apple and Samsung, no matter who arrives as the winner, the consumer will continue to lose unless the companies agree on having a healthy competition and offering their best products. So that's all from us. Thank you so much for your time and attention today. Have a nice day. Assalamualaikum warahmatullahi wabarakatuh.